Cameras turned off, the campaign has died, but the work we started, it never subsided. From the desert floor to the mountain height, we're shining the torch, we're bringing the light. 17 counties under one big sky. We're watching the records, we're asking them why. Oh, W4Nevada, the people's own desk, putting the truth to the ultimate test. For the school boards, the cities, the local town hall, we're showing up, brother, we're answering the call. From the receipts to the findings, we lay it all down. Accountability in every Nevada town. If the shadows are growing and you need some sun, bring it to us, now the healing's begun. Speak plainly, speak loud, let the truth be heard. We're keeping our promise, we're keeping our word. W4Nevada.com, you know where to go. Call or text that number, let the power flow. 702-381-4295. Nevada for Nevadans, we're still alive. Power back to the people, power back to the people.
Doing out there? Good morning. Get those skates ready. Good morning and welcome back to W4Nevada Live. I'm Matthew Winterhawk and you're tuning in to Day 17 of Coyote Springs LLC versus the state of Nevada in the $1.5 billion takings claim case. It's a bench trial as we return. Hopefully we have Harvey Whittemore. What a charismatic fellow he is. I like to watch that guy on the stand squirm and wiggle as Mr. Sylvester asks him questions in examination. But we'll get into that. I'm about an hour off from my hour update, so we didn't have any late breaking at that time. I'm still digging in the back. Keep in mind, I am running 2 different networks currently, as well as setting my children onto school. So it is what it is. Ladies and gentlemen, thank you so much for tuning in, and I appreciate each and every one of you, all 17 counties, Carson, Churchill, Clark, Douglas, Elko, Esmeralda, Eureka, Humboldt, Lander, Lincoln, Lyon, Mineral, Nye, Pershing, Story, Washoe, and White Pine counties. I want to make sure to shout out all of you, all 17, not just 2 in a sports book. We love you, Clark and Washoe. We really do. Not as much as you love yourself, but that's okay. So we had, 4 county actions newly verified this morning. The decisions occurred on earlier dates, were not made during this hour. So you had official minutes confirming and White Pine County Commission voted 5-0 on July 22nd to adopt a 180 moratorium on acceptance, processing, and approval of data center land use applications. Now, that moratorium allowed a 180-day extension if needed while the county develops data center specific zoning and special land use regulations. Regulations? What is that word? Regulations. White Pine County land use action is separate from the proposed statewide moratorium, now awaiting bill drafting that we had spoken and or reported on yesterday from the legislature. Lyon, Greenlink West in Lyon County, you've got commissioners that approved an amended NV Energy conditional use permit on August 20th, covering 3 different 345 kilovolt Greenlink West transmission lines. The amendment addresses approximately 10 miles of northern US 50 extending through the areas of Dayton, Stagecoach, Silver Springs toward the Story County line. The route crosses portions of over 15 parcels. something you need to look into if you live in Lyon County, Story County, or even Churchill. Check around that area. You got a lot going on. Douglas County, the Painted Rock Mine. You got Douglas County commissioners voted 4-0 on August 20th to reject Knox Excavating's claim that the county breached the mine's 2024 operating agreement. County staff must negotiate operating conditions, resident complaint procedures, and possible terms toward moving forward. Staff was directed to return within 2 meetings with options that could include enforcing, revising, or terminating the agreement. Commissioners also approved a 3-year, $362,450 contract with Plant and Moran for independent internal audit services. Boy, it was hard not to say moron. Moran? I don't know. Churchill County coming in $42 million in project funding. So you got planning, advancing the Fallon area improvements in the North Main Street ball fields as the 3C event complex. Project supported by $42 million Southern Nevada Public Land Management Act funding generated through the funding and federal land sales. That was announced in November 2024. County staff still talking about the final layouts are being prepared. 2024. Think about that, folks. 2 years. The 3C layout could return publicly within approximately 1 month. And we will take a look at those permits, parcels, contracts, and public money behind each one of those actions as they come up. So that's what we got on the hour. And we are still waiting. It is 9:05 a.m. Pacific Standard Time. You're watching W4Nevada. I'm Matt Winterhawk, and we'll be right back.
Yeah. Yeah. Nevada. Yeah, pull up on Nevada, feel it. Bet the ground shake when we move. Hot as it hit like sunlight. State flag wave when we cruise. Build it from the dust up. They doubt us, now they copy the groove. County by county, we solid. Same spine, different views. Made it out the hard way. Long roads, no silver spoon. Sign my name on real things. Step off planes to open skies and moons. Locked in, don't ask me about the clout talk. I might just stare at you. Locked in, don't ask me about the clout talk. I might embarrass you. Stand tall in one boots on cold stone. Holding ground steady, make them fall slow. Sunset gold match the snow tone. No front end, just stay home. Lay a land for sagebrush and railroads. They say they know us, but they don't though. Run laps around the talk shows. Hear our name echo in town halls. Yo, Nevada, where you been at? Everywhere, still working hard. 2-lane nights, wide open days. Long miles in every yard. Quick to stand up for the land. Don't push us, don't get me started. Locked in with the neighbors and locals. We keep it guarded. Everything I wear got dust on it. That mean it's activated. I was quiet when they slept on us. Now they act like they made it. Independent, proud and grounded. That's the state reputation. On top of the map for a reason. They try to underestimate it. They know this place authentic. Yeah, we live the truth. Stop over talking, show up, see what presents do. Standing on business in plain boots. Before I let this place get reshaped, I'll defend rules. Stand tall in warm boots on cold stone. Holding ground steady, make them fall slow. Sunset gold match snow tones. No front end, just stay home. Lay land for sagebrush to railroads. They say they know us, but they don't though. Run laps around the talk shows. Hear our name echo in town halls. Nevada. Battle born. Vegas shine, that's the stage. But baby, we're more than the glow. From Carson City to the back roads, we got that old state soul. Churchill ride, clock keep moving, Douglas wind through the pines, Elko sky, Esmeralda dreaming, every mile got a line. Hear that name roll slow, like a river through the sand. One state, one home, in every county band. We're Nevada, baby, Nevada all the way. We're Nevada, baby, from the night to the day. Carson City, we're Nevada, baby, Nevada all the way. Eureka Gold and Humboldt rivers, land of hills in the sun, Lincoln dust, Lyon County calling, mineral, we sing along.
Ladies and gentlemen, welcome back to W4Nevada Live. It is 9:11 a.m. We are set to reconvene at 9:15 a.m. We are at the Department 13, Honorable Judge Mark Denton, and Day 17. Harvey Whittemore is sitting there probably watching our live. Thanks for tuning in to W4Nevada Live. My name is Matt Winterhawk. 17 counties, we the people, we the press. Not just Tuna Sportsbook Club in right? So we're here. As promised, I want to make sure to let you know that this is Day 17 continuing coverage of Coyote Springs LLC versus the state of Nevada, $1.5 billion taking claim. See Hutchison, Suto, and the rest of the plaintiff's attorney team coming in. Sitting down with defense and state would be Jeffrey Sylvester and Matthew correctly. I'll have to double check and pull that name up.
And when the
Thank you so much for being on the state. It's like
we remember every
I
road.
appreciate each and every one of you tuning in today. Carson, Churchill, Clark, Douglas, Elko, Esmeralda, Eureka, Humboldt, Lander, Lincoln, Lyon, Mineral 9, Pershing, Story, Washoe, and White Pine counties. This is W4Nevada Live. I'm Matthew Winterhawk, and you are the people. And we are the press. Thanks for tuning in.
Carson City, all the way home. We're Nevada, baby, Nevada all the way. We're Nevada, baby, from the night to the day. Carson City, we're Nevada, baby, Nevada.
We apologize for that blip and switch over. You know, I always forget to hit the button to go live for Instagram. Instagram, you need to fix that. How in the world is it I can go live from the click of a button to 9 other platforms? But with Instagram and Rumble, I have to personally click the button as if I intended it. Anyways, we're back to our coverage. As you see people moving around, we have not fully reconvened. The judge himself has not returned to the chambers. When you hear them state all rise, that's when we're back in session. Thank you so much for tuning in today. You are watching W4Nevada Live. I'm Matthew Winterhawk.
So we're on 370. And I'm gonna I'm gonna do a little split screen here with this if we can, Hunter. And then if you could please pull up, this is admitted exhibit 152. And it's gonna be -1. Okay. So this on the right side, Mr. Whittemore, is an exhibit that's already admitted, and this is the state engineer's file on permit 70429.
Correct.
All right, and then that's the same one we're talking about with the well driller's report for our well that we've been talking about.
Correct.
Okay. So now let's go to, in that same file, now we'll turn to page 271 of Exhibit 152, Hunter. And this was what's in, and we've seen this already in this case. This now then is an actual report on drilling and development of well one. Okay?
Yes, sir.
Just to orient you, you can see what the date is there, November of 2005. That, of course, would have been when you were a manager company.
Yes, sir.
Okay. Now, can we please turn to 276 to 272, please, of the document? And at the very top, you can see a file stamped date up there. Again, just kind of giving us a timeline, December 5th, 2005. The document itself is dated November of 2005. And you can see then about 2/3 of the way down who prepared it, Michael Johnson, consulting hydrologist. And you're familiar with Mr. Johnson.
Boomer.
Yes, Boomer. Okay. Somebody who you knew well and worked with while you were at Coyote Springs.
Correct.
Okay. So he prepared this. Now let's go to 293 and see what Boomer tells us. So in the summary, page 293, you'll see what we'd already seen in the well digger report. If you go down to the summary, it's about, I don't know, halfway down that first paragraph, the 20-inch diameter. You see that?
Yes, sir.
And then it just tells you how deep the casing went to a total depth of 1,016 feet below the land surface. And we saw that in the well diggers report previously, right?
Correct.
Okay, now if we go to the next page. Now we'll get to just this gallons per minute. So if you look at the top paragraph there, the constant rate test started at 8 o'clock on September 30th, 2005, ran continuously through October 1, 2005, at an average production rate of 4,223 gallons per minute over the duration of the test. So you see that really was a lot of water, over 4,000 gallons a minute.
Yes,
So
sir.
just wanted to answer that question for you. So we're talking about, I think we can agree, a lot of water in that well too. Would you agree?
Agreed.
Okay. All right. Let me now take us to our next part, our next drill report, which is Exhibit 268. If we go back to that, Hunter. And let's see. So we go to Exhibit 268, and we're on page 368. And now this is going to be then for well number 3. You can see that in the upper left-hand corner there, Mr. Whittemore. You see that?
Yes, sir.
Okay, great. And you can see there's a permit number there on the upper right-hand corner that we've been looking at that area. This one's 74094, and I think we can agree that that's the progeny of the 4677.
I'm not familiar that 74094 is.
Okay, so that's a permit that you're not familiar with.
I thought the other number ended in a 30 and a 29. I'd have to. Can we go back?
Yeah, you want to go back to our prior exhibit?
Yeah.
Okay.
Yes, sir.
Yeah,
That's
we can go back to 370.
70429 is one, and I thought 704230 was the other.
Yes, both of those, exactly right. And now this is a new permit for drill for well 3.
I understand. What I'm saying is I'm not sure that it's 4677.
Oh, I see. Okay.
I don't know that we've established that was.
Okay.
That's all.
You just don't know that. Okay, that's fine. We do see the reference though to that permit number, whatever that is, in terms of a standalone permit, or if that's a progeny of 4677.
Okay.
All right. The work performed is the same as before, the new well, right? And the proposed use is, again, municipal and industrial, as we've seen, municipal purposes.
Correct.
And this time the depth of the well is 1,156 feet. And let's see what what occurred at that level. You can see in the bottom left that there was then a gallons per minute constant rate of 3,263 gallons per minute. You see that?
Yes, sir.
So, and the date on this one, we didn't note that, but you can see the stamp date there. You can also see the signature date, February of looks like February 16th is the state, or March 16th is the stamp date, and February 14th of 2007 is the signature date. Just to orient ourselves.
Yes,
See
sir.
that?
Yes, sir.
All right. So CSI then and Party once again hit water under a permit issued by the state engineer.
Yes, sir. Can I see where the location is? Can you move up? Hunter?
Sure.
Just to orient myself here. Is this how many miles away from 93 and
If you look
168?
at address at Wells
That's
location.
1 mile north of intersection. Thank you.
Yeah, you bet. Okay.
They're all in the same general area, but they're at different locations, spaced appropriately.
Okay.
Thank you.
Thank you. Let's now go to well 4, which is page 368. No, that's not 368. It'd be 367. I said 36. Sorry. 369. Okay, we're at 369. Now we see a permit number 74095. Is that something is that a permit number you recognize as a progeny of 46777?
I don't. Yeah.
Okay, can't confirm that. That's fine. You can see though this is well 4.
Yes, sir.
Okay, and same information basically as what we've seen previously. It's for a new well, municipal purposes. Then the depth of this well is almost 1,400 feet, 1,397 feet. You see that, of course.
Yes.
And then let's see what the constant rate of gallons per minute was. It was 3,300. And the date there, you can see clearly a stamp date of August 11, 2008. You see all that?
Yes, I do.
And so under this permit, Party and CSI under this permit drilled a well, went out and found available water at almost 1,400 feet, and the gallons per minute was 3,300 gallons per minute, correct?
Correct.
Okay. All right, so Mr. Whittemore, are you aware, this would have been during your time frame, but are you aware that CSI and or Pardee submitted to the state engineer proof of completion of the work involving these 4 wells?
I was aware that we had filed everything that was required by the state to continue the works, proof of completion, and this is starting to put the water to beneficial use.
And that was going to be my next point, which is this is beginning the process of what we've talked a lot about, which is doing the work to put the water to beneficial use.
Correct.
Okay. And the state engineer acknowledged and received, at least to the best of your knowledge, that proof of completion for this well.
Yes, sir. They did.
I should say these 4 wells.
Yes, they did.
Okay. And as a result of that, CSI and Pardee then moved forward with development of the Coyote Springs community using the water that was available from these wells, correct?
Yes, we did.
Okay. We've seen under these permit and these well digger reports that the state engineer issued the permits. CSI and Pardee went out, began to put the work in necessary to put the water to beneficial use. The wells were productive and the water was actually put to use. For example, dust control,
Yes, sir.
eventually watering the golf course,
Yes, sir.
other uses,
Nursery,
nursery.
significant,
Why was that significant, the nursery?
because we were preparing to develop plant material for the community, as well as bring pine trees from another location in Moab to our nursery to add product to the golf site. We tried to have an integrated operation where, Your Honor, we used material which we grew or purchased and matured and put it on the golf course, so you had a more completed look when the golf course opened.
Okay. Any other usage you can think of besides those? that we've discussed?
But I think we previously discussed about the fact that we sold part of that product to Steve Wynn for the opening of the Bellagio.
Right. Okay.
No, not the Bellagio, the Wynn.
The wind, yeah, okay. Before you can start to use that water for dust control or for watering the golf course, there had to be infrastructure then that had to be constructed from the wells to, for example, the water treatment plant.
You ultimately did. What we did at the beginning is we analyzed the water to determine what the heat levels were. It was warm. It was, probably 80 to 100 degree water. Look at what the total dissolved solids were to see what kind of standards it would be. We used above ground piping to put it into storage facilities, used pumps to develop and put in the irrigation systems. But long term, there was a water treatment plant constructed.
And there were water tanks, storage tanks.
Yes, sir.
There's a wastewater treatment plant eventually.
Ultimately.
Yeah. Miles of pipe to transport that water around?
Significant.
Okay. All right. Mr. Whittemore, I just want to touch on a subject that the council had asked you about. There's been a suggestion that your development plan for Coyote Springs was just kind of in your head. It was just this informal in your head. Is that how you describe your development plans for Coyote Springs?
Objection, mischaracterized as record, Your Honor, also vague as to time.
What?
He said that my question was, this development plan was in his mind. That's not the record, nor is it his question specific as to the time of the proposed.
You want to rephrase the question?
Sure. It's not a mischaracterization. It's a quote. Council said to you that your development plan, basically, when he was summarizing a bunch of your testimony, that plan was basically just in your head. And I want to give you a chance to comment on that, whether or not the development plan was just in your head.
The genesis of the Coyote Springs development was a thought process. It starts as a kernel, an idea, and then you put substantial effort and thought into creating a very precise sort of analysis of what you can do or not. I think that what we were talking about with other counsel was the fact that, Your Honor, the bulk of these things are contained in my thought process and then ultimately transmitted by direction to other staff people to implement. I'm been characterized as an idea guy, so I think that might be the reference point, but certainly I don't believe you can go forward and do what we did with just an idea in your head.
And you've said that your decision wasn't made on the back of a napkin.
No, sir.
Okay. You followed the proven Wingfield Springs master plan development that we talked about very early in your testimony before. I'm not going to have you repeat that testimony, but that was part of your plan, right?
Yes, sir.
And as well as all the other things that you've talked about during the course of this trial.
I think it's fair, counsel, that all of my life experiences informed how I proceeded with respect to these types of transactions.
Thank you. All right. Now we discussed previously that you testified before the state engineer on that 1169 order, right?
Yeah, yes, sir.
Okay. Want to orient you there.
Yes.
You during the time that you were before the state engineer, you made the state engineer well aware of the amount of money that was being invested in Coyote Springs. Would you agree?
I think at the opportunities when I was under examination or make presentations, I tried to articulate the level of commitment that had previously been made, or up to that time. I think, every opportunity as you went through this process from the time of closing until I left, we had spent significant sums. And when I was making presentations, I'd tell people what I thought we had in the project.
As a matter of fact, at that hearing, the 1169 order hearing, you informed the state engineer that to date, Coyote Springs has spent $33 million.
I think that was fair.
Okay. And during that hearing, you had informed the state engineer that CSI was ready to move forward and was in a position to begin the first of 2 golf courses in the early village center and residential component of phase 1.
I think that's fair.
And you also then informed the state engineer at that same hearing that CSI expected to spend between $75 million and $100 million on phase 1. Correct?
That would have been a pretty good estimate, I think.
Okay. Now, Mr. Whittemore, you also testified that it was CSI's plan to use the water rights that it controlled within the basin for this first phase 1.
Yes, sir.
Okay. There's been some discussion with State's Council about the temporary use of CSI's water for like bottling purposes or making ice. You remember that subject being discussed?
Yes, sir.
Okay. Mr. Whittemore, you informed the state engineer that you intended to proceed with the CSI development and put CSI's water to permanent use, correct?
Yes, partially. I as I indicated, I was seeking water that we could provide to the residents, and therefore it would have to be what I consider to be a permanent use.
Thank you. During that testimony before the state engineer, you expressed no doubt about the availability of CSI's water rights to proceed with phase 1, right?
I didn't think that there was that we needed more water from any source other than the wells that we had drilled, the water that we thought was available under 46777, that portion. Yes.
And that first phase, you were always, as you testified before, looking out for more water. But you plan to move forward with phase 1 based on the water that you already had within the basin, that 4677 water, correct?
Yes, sir.
Okay. Now, as you've talked before many times, no one knew exactly how much water was in that aquifer underneath Coyote Springs, but you testified to the state engineer that there's no doubt that there is an excess of water available based on everyone's models of in excess of 16,300 acre feet. Do you remember that?
I recited the best available science and said, if you look at all the models, everybody believes there's significant quantities. And I thought that the 16,000 was the bottom floor.
And you've talked about that before, about just, there were a lot of people who were well-informed who were telling you there was a lot of water out there.
I relied on Mr. Katzer, Mr. Moros, what state engineer Mike Turnipseed found. Again, the estimates were that there was a significant quantity of water.
Thank you, Mr. Whittemore. I reviewed some of your statements about Coyote Springs during the course of that litigation involving party.
Okay.
I just want to turn your attention to that. I know this is back in 2013. Okay. You, Mr. Whittemore, testified or made a statement that you've just repeated what you've already said here, which is it's essential to have water if you're going to develop Coyote Springs.
Okay.
For residential purposes.
Yes, sir.
And in fact, you would not have begun to develop Coyote Springs without water.
Yes, that's why again, going back to what we were trying to do is to make sure that the Aerojet permits were pursued, and that when I identified the Nevada Power water, that I went after it.
And I was interested in your discussion about you felt like it was important to get to an actual water permit, like the 4677 permit, to get that in hand. That was important. We talked about that.
Yes, to get a permit in hand.
In hand. And The reason you felt that was important was because then you could control your own destiny, because then you could control doing the works to put the water to beneficial use.
But
that fair?
That would be a fair characterization.
Okay. Now, Mr. Whittemore, we know that you left CSI around 2010, the end of 2010.
11, you somewhere
Roughly.
there. Mhm.
So you had about 12 years with CSI. Roughly.
Yes, okay.
And you were asked questions about Miss Cargill. Miss Cargill arrived in, I think, May of 2006.
Yes, sir.
Okay. And she's been there for the last 20 years, to your knowledge?
As far as I know.
Okay. So based on just that time frame, Mr. Whittemore, is it accurate to say that after 2010, you would not have known about communications between CSI and the state engineer's office?
Unless I was advised for some reason, that's correct.
Do you think of any time you were advised for some reason?
I might have received copies, sort of a remnant legacy of being on some sort of mailing list or notice, that sort of thing.
Okay. Anything come to mind now that you received, or just would it have been remnant stuff because you were still on somebody's mailing list?
That's correct.
Okay.
Nothing that would have not been identified by me as having been received by a principal or someone in authority other than myself. In other words, if it came to me and it was something that was not identified on the letter as having been delivered to someone else, I would have transmitted it on to the appropriate person.
Okay.
Excuse me, let me finish if I
Please.
can, I'm sorry. For example, I still receive mail from people trying to give Red Hawk Land Company credit cards. Rip them in half, throw them away, that type of stuff. You can see that other people still have me associated with stuff that's
Yep.
just irrelevant.
But is it fair and accurate to say, Mr. Whittemore, that since 2011 forward, you've not been involved or known about the substantive discussions, either personally or emails or even correspondence communications between CSI and the state engineer's office?
None whatsoever.
You didn't keep up in terms of what permits were issued by the state engineer after you left, did you? Just, again, be clear, issued to CSI?
No, I did not.
Okay. Do you know the current status of the 6 water permits of CSI?
I do not.
Okay. You weren't involved in or had knowledge about any of the extensions of time that the state engineer granted at the request of CSI
After I left, no.
after you left? Okay. And is it safe to say then that you would not have known about any of the state engineer's inspections of the wells after you left,
No, sir.
or the wastewater treatment plant,
Not at all.
or the groundwater facility?
Not at all.
Okay. Detention basin?
Not at all.
Okay. I take it then that you wouldn't know about any of the fees that the state engineer charged to CSI concerning those inspections, or any of the activities they were involved in concerning CSI,
No, sir.
or the taxes imposed by the state?
No, sir.
Okay. You would not know about the emergency action plan that the state engineer requires CSI to have?
No, sir.
Okay. Or whether they continue to require that today?
No, I do not.
Okay. From 2011 forward, is it safe to say that you would not be aware of CSI's coordination of work and projects with various state agencies like NDOT or NEPA or other agencies?
I had no involvement.
Okay.
And I'm not aware of any.
Thank you. I take it then that you're not aware of the current status of CSI's entitlements or offsite improvement bonds?
No, sir.
Okay. Wouldn't know about, I take it, Mr. Whittemore, any of the documents that were produced in discovery in this case from 2020 to 2026?
No, sir. other than those that you might have provided to me in preparation or were provided to me in preparation of deposition or that we've reviewed.
Okay, so there were some documents that I didn't provide to you, but Mr. Sylvester's office did.
Yes, sir.
Okay, so if they were provided to you then in preparation for your deposition, maybe you'd seen those.
That's correct.
Or maybe you'd seen something on
That's
the
what I'm saying.
screen here in trial.
Yes.
But other than what's been shown to you, or you testified about your deposition or here at trial, you would not have seen those discovery documents. Is that fair?
Correct.
Okay,
Did not independently go and review any documents, did not try to bring myself up to speed, so to speak.
okay, thank you. And so likewise, you would not be aware of the deposition, many depositions taken in this case. Didn't go back and review any of those deposition testimonies, right?
No, sir.
Okay. None of the former state engineers' testimonies, you wouldn't know about those?
No, sir.
Wouldn't know about Melissa Flatley's 30B6 testimony
No, sir.
or Steve Shell's testimony?
No, sir.
Okay. And Mr. Whittemore, you would be unaware of the internal state engineer staff emails obtained only through discovery in this case? Those would be included within discovery documents, right?
Correct.
Wouldn't know about any of the internal state engineer staff emails that were sent and communicated to each other 5 days before the state engineer entered into a settlement agreement with CSI?
Not aware of that.
And you wouldn't be aware of the terms of the settlement agreement?
Not at all.
I take it, Mr. Whittemore, that you're not aware of CSI's submission to the state engineer of reports by Stetson Engineering in 2018 offering a framework for the management of the lower White River flow system,
No, sir.
or the 2019 Stetson report that sought to provide evidence in support of an adequate and sustainable supply of water for CSI's maps that have been submitted?
No.
Okay. I don't think you did, but I'm going to ask you, you didn't attend any of the public workshops presented by the state engineer regarding order 1303 or 1309, did you?
No, I did not.
Okay. Wouldn't be aware then of what the state engineer presented at those workshops or in those meetings?
No, I was not.
Okay. Didn't attend or know anything about the so-called phase 2 administrative process within the state engineer's office?
Not aware of it, sir.
Okay. So, Mr. Whitmore, is it accurate to say that your testimony during Mr. Sylvester's examination would not have been informed by your knowledge of the subjects that we just described?
No, it would only be based upon my personal knowledge from the time that we started CSI until the time that I left. That's my personal knowledge.
All right. Thank you very much, Mr. Whitmore. You've been a gentleman. I appreciate your time.
Thank you so much.
Any costs?
Yes, sure. Thank you.
Good morning.
And so I want to start towards the end of council's discussion with respect to 1169.
Okay.
We have discussed, and the court's aware of the purpose of the 1169 hearings and ultimately what the 1169 order provided. But just from a timing perspective, we look at some of those drilling logs, and it seemed to me that those wells were established or drilled sometime after the 2002 time period, or do you know?
Yes, I think the earliest well driller's report might have been 2004,
And
I
that,
believe.
I think I saw maybe 2003 to
yeah.
2000. Okay. So the wells were drilled after the 1169 order came out, which was in March of 2002. Is that a fair?
I think that's fair.
And when you attended the 1169 hearings, no water had been pumped from Basin 210, at least not a significant amount of water.
Only the water that had been pumped as a result of the MX-5 missile test, as I recall.
And that pumping occurred in, was it the late 80s, you recall?
Correct, the late 80s, I think.
And that was done in connection with the, ultimately the Nevada-Florida Land Exchange Act on a go-forward basis by Aerojet. Is that generally accurate?
Yes, I believe so.
And that wasn't a permanent pumping, that was short in duration to see whether there was water essentially beneath the surface in a carbonate aquifer. You recall that?
Correct. It was, again, done in conjunction with the U.S. government's attempts to put the mobile MX missile silos within the state of Nevada.
That wasn't a pumping that was done essentially by the state engineer. Would you agree with that?
That's correct.
And that water that was pumped for the purposes of determining whether it would support the missile system was never actually put to beneficial use. Do you agree with that?
Correct.
And that was also done in connection, well, let me withdraw the question. So at the time of the 1169 hearings, wells haven't been drilled by CSI. And you have 4677 that had been issued, correct?
Correct.
And 4677 was highly conditional, agreed?
Agreed.
Okay. Couldn't interfere with existing rights, correct?
Correct.
And it retained the right, the state engineer retained the right to regulate that permitted water, correct?
True, as I previously indicated, my testimony is that the state engineer retains the right to regulate all statutory rights after 1913.
For the benefit of the public, because the public owns the water, agreed?
That was my testimony still.
But it was not limited to that. It was limited, it included the monitoring requirements as set forth in 4542 and 4677.
That's true that there was a monitoring program listed as a requirement.
And that monitoring program, if you can recall from 4542, was merged with the other monitoring program that are already started in the, I think it was Basin 219. Do you recall that generally?
Yes, well, there was an effort to provide a more regional approach so that we could get a good monitoring program to establish a more region-wide snapshot.
Right, so that there could be some understanding as to whether the pumping in one basin impacted the existing rights in another. Fair?
I think that's what the terms of the permit are.
And there was also some concern in 4542 as it relates to the impact on any endangered species. Agreed?
I believe that the endangered species issue flowed prior to the Nevada Florida Land Exchange Act and contained in that act, as well as the terms in multiple state agency letters. So I think it's fair to say that there was a concern about the Moappidace, and we've had that discussion.
We have, and there were some protests of 4542, including but not limited to protests by Fish and Wildlife.
True statement.
And so essentially at that point, the state engineer is attempting to jointly administer those two basins so that pumping from one didn't impact the pumping from the other. Agreed?
Objection, foundation. Sustained.
Do you have an understanding, sir, one way or the other as to the purpose of having those merged monitoring plans across those basin lines?
It was my understanding that the state engineer wanted to get more information about multiple subjects, including impacts in the surrounding area. Again, I don't think that I recalled that we've had this discussion. I don't know that there was physically, I had a memory of, 210, 219. What I was concerned about was, is this going to impact the Muddy Springs? Is this going to impact downstream users? Is this going to impact other users who could make my life difficult where I was?
You were concerned about impacts on other right holders in the same source. Agreed?
I think that's fair. That's what I testified to.
Regardless of the basin lines established by the USGS back in the 1960s. Agreed?
Agreed.
Okay. And so when you're testifying at the 1169 hearings, you have those conditional rights. You are aware of the Nevada Florida Land Exchange Act, its limitations. Agreed?
Agreed.
And you're attempting to ask the state engineer to approve the additional 108,000 acre feet because you believe that was necessary, all or a portion of it, to go forward with the master planned community. Agreed?
I wanted additional water because if you're going to go forward with the entire development on the 42,000 acres, you need more water than was available under 46777.
And that was your intent at that time, to develop the entire 42,000 acres as a single master plan community, at least as of that date.
As of that date.
And when you testified that you had spent $33 million as of the 1169 hearings, that would have included the acquisition price. Would you agree?
In my prior testimony, I said I think I said that I didn't know whether it included it or not, but it would be subject to an accounting check to see.
Sure.
And so I thought that the number was accurate. I don't think we had put $33 million in excess of the acquisition.
You hadn't drilled the wells,
No, sir.
and that would have been a significant expense. And so you hadn't drilled the wells or put in additional infrastructure.
No, we were trying at the time. I think what I was trying to do was to estimate the expenses associated with all the entitlement costs, all of the discussions. So I think it was a fair number, but I can't sit here, as I sit here today, I can't tell you exactly what was included in that estimate.
And you were at that time projecting a significant expense for the development of the master plan community. Agreed?
Very much so.
Now, at the time, as you may recall, the 1169 order, when it came out, there was a requirement to pump the then existing rights in Coyote Springs. Agreed?
Agreed.
And that's because no pumping had occurred beyond the MX5 pumping earlier in time from that basin, correct?
Everybody associated with the project and those that were required to regulate the project wanted more information. The only way we could do that is to have a pump test, and therefore the requirement that you have a pump test would have been done without government regulation. You would have done pump tests, and so the information before the pump test, after the pump test, informs how you go forward and what you do.
And that pump test was on a regional basis. Do you recall that, sir?
The pump test, which was proposed and ultimately done, it was done on a regional basis.
And I think, and maybe you know this, maybe you don't, there were 79 monitoring wells across that regional basin. You recall that?
I don't recall the total number, but I know that it was a significant monitoring program where you developed information at various well locations, had monitoring devices within the well casing and determine the water levels, those sorts of things.
Right. In 4542, when that was approved, there hadn't been pumping in Basin 210 other than what we talked about on MX5, three.
Agreed.
And so at the time you understood, sir, when 4677 was approved, it was based upon the then best available science.
Agreed.
And then 1169 was an attempt by the state engineer to further obtain the best available science to make determinations as to how best to manage the public's resource.
I would agree with that.
Because as at that date, it didn't exist beyond the initial monitoring plan that was done in Basin 219. You agree?
Objection, lacks foundation as to what information is available.
Sustained.
Sure. Do you know, sir, if there was any other pumping information other than that was done in connection with the issuance of 4542 prior to the 1169 order?
I was unaware of any.
And the 1169, I'm sorry, the permitted 4677 required the monitoring program, correct?
That's correct.
But that hadn't been instituted yet because in part the wells hadn't been drilled.
That's correct.
And those monitoring plans weren't approved until approximately 2005. Do you have that general recollection?
Yes. By way of explanation, we developed a monitoring plan which included the requirement to drill the well so you could get the information. But the point is, you have to have a plan in place and then you start to implement.
Sure. But the approved plan wasn't actually approved by the state engineer until after the wells were drilled.
Some of them.
Right.
I don't know that all of them were, but yes.
I was just looking at the drilling logs that council had showed you, and it appeared to me perhaps one was in the 2008 time period.
Right.
1, 2, or 3 of those wells were drilled for the purpose of essentially establishing a monitoring plan.
Objection lacks foundation.
Sustained.
I'm asking, sir, your understanding of the purpose of the monitoring plan and why you built those wells in advance of the monitoring plan.
We were in the process of developing a monitoring plan. There were draft monitoring plans as far back as NV Power proposing a monitoring plan, which was then modified. So the process of developing the monitoring plan took place from the moment that we started to acquire 46777 until the monitoring plan was approved. Between that time, Your Honor, we drilled wells in anticipation of ultimately getting the monitoring plan approved.
And at all times on that continuum, because pumping hadn't been started, the wells hadn't been drilled and the monitoring plan hadn't been approved, there was certain risk to CSI that, one, there may not be any water. Agreed?
Objection foundation.
Asking for his understanding.
Overruled.
There are risks associated with drilling wells successfully at economic depths, at certain costs. Because we were trying to ensure that there was a sufficient quantity of water, you needed to have the wells produce that. If you take a look at the combined water in the 3 wells and then the 4th well, you saw that there was a very significant amount of water on an annual basis. So again, you go through that process, but it's very risky. You could hit a dry hole. You could, it could have, if you're not in the carbonate aquifer or don't hit the carbonate aquifer, Your Honor, you could hit water which has significant TDS and other chemicals in it that would make the water unusable, like arsenic, those sorts of things. Throughout the state of Nevada, there are pockets where you have that kind of issue.
But the availability of water is one component. Agreed?
Correct?
But whether or not that water can be appropriated without conflict is a different component. Agreed?
Objection foundation. Calls for legal conclusion.
I'm asking his understanding.
Agreed.
Okay. And so I don't think anybody disagrees that there is a significant amount of water in the carbonate aquifer. I mean, I think that those predictions were probably fairly accurate, but nobody had pumped it to see what the effect would be on the source and supply of water on other right holders. Would you agree?
Objection argumentative.
Overruled.
Agreed.
And so part of the process is you have to measure that risk. And because at the end of the day, because you're on notice that it's subject to existing rights, the pumping of that water may in fact impair other rights in the region. Agreed?
Objection. Calls for legal conclusion about notice.
Overruled.
Agreed.
And even if there is water, it may well be that the best then available science indicates that that water can't be appropriated without impacting, for instance, the decreed rights. Agreed?
Objection. Calls for speculation. Lacks foundation.
Overruled.
That's a correct statement.
It's also a potential risk that the appropriation of that water may well impact the endangered species located in a different basin. Agreed?
Objection. Foundation. Speculation.
Overruled.
I previously testified I was concerned about the impact that our use of the water might impact the Moabitese because they said you have to be concerned about it. So if you read it, you have to be concerned about it.
Yeah, it's notice to you that there might be an issue. Agreed?
That's a fair statement.
And I'm not suggesting that it wasn't reasonable to go forward and assume that risk, but it was just simply a known risk at the time. Agreed?
Objection. Foundation.
You can say his understanding. Overruled.
Yes, it was a risk.
But you tempered that risk because you had advice from folks like Terry Katzer and Mr. Morris, right?
I was comfortable based upon the information which others a lot smarter than me gave to us so that we could proceed with the project.
Including the acquisition of water rights by SNWA where they paid that much money, right? 25%.
That previously testified that I believe that their acquisition of a portion of those water rights signaled to me that there was sufficient water for us to proceed with the project.
But nobody told you, Mr. Whittemore, that the appropriation of that water wouldn't impact existing rights. Is that a fair statement?
Objection, mischaracterizes prior testimony, asked and answered.
Overruled.
That's correct, sir.
And one of the agreements that CSI entered into was that agreement known as the Memorandum of Agreement. Recall that generally?
Well, there were so many. If we could pull up the exhibit number, I'd look at that.
I'm going to refer to the one in 2006. And that's when the agreement was entered into by, among others, SMWA, and I think Muddy Valley Water District. It was an attempt to.
If we're talking about that agreement, I generally understand it. Yes, sir.
That's in 2006. So that agreement hadn't yet been put in place to protect the days until 2006, though there may have been one earlier.
That formalized our effort to ensure that the days was protected, Your Honor, by coming up with a plan. And that was based upon all the information that the federal agencies gave us, the people that I was having meetings with saying, what do we need to do? Because I don't want us to go down the road without having a plan in place to protect the days. That's why we ultimately came up with providing 500 acre feet and X% of all future water coming in to protect that endangered species. I knew that that was a full stop hurdle that needed to be negotiated against, and a process in place so that we could clear that development hurdle.
I told you a long time ago when you were first here that I'm not here to criticize you, your judgment, or your efforts. And so don't take my questions that way. I'm just trying to.
I'm not.
Timeline.
Okay.
But again, part of the MOA, the 2006, was to develop science to determine whether or not there was going to be an impact on the Moabit days, and if so, how to protect it going forward.
Objection, ambiguous as to the use of the word science.
We've used the word science a number of times, best available science, best then available science. Did you understand the term science in those contexts?
I did.
Okay, so let's use best available science since that's something that you understand. Not that you don't understand the term science, but part of the MOA was to develop best available science to make certain that the appropriation of water didn't impact the downgradient endangered species. Agree?
Part of that MOA was designed to do that.
Then there were trigger levels, as you recall, maybe set in that agreement that said if it hits this certain trigger level, that we may have to change it or make.
Yeah, there were triggers, Your Honor. The early warning system that we talked about in my testimony about how we would ratchet down the use and potentially have to supplement it. But the point was that all of that was done with the general understanding that there was going to be, there's water there.
And there is.
Yes, sir.
We just don't know whether it can be appropriated without affecting the downgraded and adjacent rights. Agree?
Objection,
At the
foundation.
time. At the time.
There's a foundational objection.
Foundational objection, yes, as to his knowledge and also as to time.
Okay.
We were talking about the
Sustained.
2000. Sorry, we were talking about 2006 MOA. I think you and I were, was to determine, at least in part, to see how the pumping of that water impacted the Moabit days. Right?
I think that's a fair characterization of the document.
Going back to 1169 and consistent with your testimony yesterday, you knew and understood from your testimony in 5918 and Mr. Sabley's letter that we looked at again yesterday, that to the extent that the pump test revealed that the pumping of water out of Basin 210 had an impact on the decreed rights for the Moabit days, that those permitted water rights could be restricted or curtailed. Agree?
That's a correct statement of Nevada law as applied in this case, along with my general understanding of what the terms and conditions of the permits were.
And 1169 provided notice to you that, in fact, that there's going to be an impact, your rights could be regulated or restricted, in addition to what the permit terms say.
I think you have to read the terms of both the permits and conditions on the permits, along with any relevant applicable orders attached to those particular permits. You have to read everything together, and I think you could draw the conclusion that that's what the state engineer was trying to do.
And you did. When I say you did,
CSI.
see it, but probably you
Yeah.
read as much of the materials as you could. You read, we talked about in your first session, some of the Econ reports and a portion of the Devenger report, and you're aware of the Carbon Terrain Society. I mean, you did your homework. Is that true?
Yes, it is.
And you understood at the time the permit was issued that those basins may well, all of the basins may well be hydrologically connected.
I read that. I was told that. I understood that the experts were saying that that's what that was.
But to be fair, even though you knew and understood that there were senior statutory rights in Basin 219 and the decreed rights, you weren't particularly concerned because everybody had told you there is a significant amount of water in the aquifer. Is that fair?
Their representations and information provided to me, Your Honor, made me comfortable enough to continue to proceed.
Or to assume that risk?
That's
Objection, argumentative, calls for speculation.
I'm asking
State
you.
foundation is to assumption of risk.
Sure, we talked about assuming the risk that even though the permits had been issued, they hadn't been pumped. We talked about 1169 requiring that the pump test occur because they hadn't occurred in Basin 210. And that on a go-forward basis, you were going to be making improvements with an assumption of a risk that that water might not be available for development. Agree?
Objection, mischaracterizes the evidence of the case.
Overruled.
I understood that I couldn't go forward with the development unless I had sufficient water resources. Therefore, to get to sufficient water resources, I understood that I needed to make sure that I got as much as I could, more.
Yeah.
And I understood that that first base right might be impacted, but I thought I could supplement it with additional water, which is why we negotiated Cane Springs, why we went to Lincoln County and Bidler. I was attempting to create a, we've talked about it, to de-risk the venture by doing what we did. And I thought CSI did a good job doing that.
Don't disagree. I mean, that you testified that Tuffy Water Ranch property was the most significant purchase that you made beyond the acquisition of the property, right?
Correction, asked and answered.
Overruled.
And so when you talk about de-risk, that presumes a risk that you're trying to de-risk, agreed?
Objection, argumentative, foundation, speculation.
Overruled.
Agreed.
And so on the continuum, I'll represent to you, sir, that CSI has presented evidence in this case that by the time December 31st, 2007, CSI had expended approximately $102 million in the process of developing it. So accept that premise is true. As I understand it, and you will agree, the pump test didn't begin until 2010, right?
Yes, that's correct.
But you are continuing to make the improvements by de-risking the issues associated with the base permit by doing the things you said, acquiring the Cane Springs water rights and acquiring the Tuffy Ranch water rights, correct?
Correct.
And entering into the capacity agreement with Bidler or Lincoln, assuming the obligations related to the S&W pipeline.
The capacity within the Southern Nevada Water Authority pipeline. Yes, sir.
And so you are making progress attempting to de-risk that risk we've talked about.
I'm trying to identify 5 sources, 10 sources, 15 sources, as many things as I can do.
And the other thing you wanted to do was buy any rights in adjacent basins that may complain that the pumping of CSI's rights impacted their rights. Agreed?
Agreed. It was a direction that I gave to staff. My staff. My team. It's a better way to say that, you know.
want to, Mr. Whittemore, talk to you a little bit about, maybe a lot about those loan documents that you were showed by council yesterday. Find them. Right. Lindsay, may I have exhibit, CSI's exhibit 534, please? Cole, you were shown yesterday, the loan agreements, and Lindsay, if you go to, 493, please, of that document. While she catches up, there we go.
Yes, sir.
Let me get there. Darlene, can we start at 439? My dyslexia caught up to me. You were shown yesterday two different loan agreements. One was in the 2005 time period, and then 439. So I am. Yeah. We found it. We were shown two documents yesterday, two loan agreements. This one is the second of the two. You saw one in 2005, and this is the one in 2007. Sir, do you recall the reason why or the purpose associated with this amended and restated loan agreement, increasing the credit facility to 150 million?
We wanted to develop a credit line that allowed us to proceed with the development plans associated with Coyote Springs, including any necessary construction activities, acquisition costs, additional expenses associated with paying payroll, doing everything.
Okay. And can we now turn to 493, please, Lindsay? And if you can just highlight the 7.1 at the top, representations and warranties. And these that will follow will be the representations and warranties of CSI, correct?
Correct, the borrower.
Now the collateral, we'll talk about the collateral in a moment, but these were personally guaranteed by you and Tom Sino. Do you recall that generally?
Yes,
Now, generally speaking, and you have had a borrower-lender relationship with financial institutions in the past, haven't you?
yes, sir.
And oftentimes they require collateral, including real and personal collateral, correct?
Correct.
And frequently they require the guarantor's financial records, agreed?
Agreed.
They would want to know, for instance, whether or not the borrower had the guarantor had the financial wherewithal to repay the debt to the extent that all or any portion of the collateral is insufficient to cover the debt, agreed?
Agreed.
And you submitted your financial information, agreed?
Agreed.
And so too did Thomas?
Yes, sir.
Yeah. All right. And it was a requirement that the guarantors be solvent. Do you recall that generally?
Yes, sir.
And Lindy, if you go to 454, please. And you see the definition of solvent? She's not there yet. There you go. If you highlight the definition of solvent, please. Means when used with respect to any person that a fair value and the fair saleable value of its assets, excluding any indebtedness due from any affiliates of such person, are each in excess of the fair valuation of its total liabilities. And so it's fair to say that you and Mr. Sino demonstrated your solvency in connection with these applications?
Yes, we did.
Do you know what Mr. Sino's net worth was at the time, or generally?
Objection, Your Honor, irrelevant
It's relevant. Your
and
Honor.
confidential.
I don't know how it's confidential. The issue, they brought these documents into evidence that required financial solvency.
Yeah, if that doesn't disclose than a non-party who's a principal to a party, but doesn't disclose than a non-party's net worth or what their financial conditions are, Your Honor. The fact that they made a representation, they were solvent back in 2005.
Are you finished? I disagree, and let me tell you why, Judge. They put this issue squarely before you with respect to the collateral and the value of the collateral and the reliance of the bank on the proposed collateral. And I'm trying to demonstrate that there was other assets sufficient to support the loan, in addition to what they have led this court to believe is a single permit of 46777.
Your Honor,
I think it's relevant.
Your Honor, this is irrelevant. And secondly, if there's going to be any discussion about this, about what Mr. Sino's net worth was back in 2007, first off, I'd like to be able to retire the witness and see what his knowledge is about that, but I'd like this all to be confidential and in a closed setting.
I don't have a problem with that, and I can just ask him first whether he knows. If he doesn't, then that ends the inquiry.
I'll allow that as a yes or no.
Sure. Do you know generally what his financial net worth was?
But wait a minute, not generally. He wants to know what the net worth is in 2007 of Tom Sino. And that's a yes or no answer.
Yeah. So I'll ask the question, counsel.
Your
That
Honor,
was my question.
Your Honor.
It's an objection.
Your Honor.
You're questioning the witness.
Your Honor. Your Honor.
Let's get to the question and then you can ask.
Your Honor.
Do you know,
May I be
sir?
heard? May I be heard?
Hold on just a moment. Yes.
Thank you. Your Honor, I'd like it to be then a yes or no question about his specific knowledge about the net worth of Mr. Tom Sino as of 2007. That's what I'd like.
I'll incorporate counsel's question.
Thank you, Your Honor.
Excuse me, Your Honor. Now I have a clarifying question. Are we talking about at the time of this document?
That's correct. Yeah.
What, is this 2005?
This is 2007.
7.
Thank you.
It's a yes or no.
Yeah, not,
Yes,
not how
yeah.
much, whether you know. Generally.
Yes, generally.
And again, Judge, that was my point of the whole question was, yes, generally. I asked it to be specifically, do you know specifically what his net worth is?
I didn't ask that question. I asked
I
you.
know, but we just got
That's
this.
now specifically.
Do you know specifically what his net worth was? What he actually reported to the bank in 2007?
No, I do not.
Do you know generally?
Yes, generally.
But that's the same question. And first of all, I don't think any of the bank loan documents are relevant, which is why I lodged the objection. They put these through and extensively examined Mr. Whitmore on these documents. And I want to know what the collateral base was and whether there was a sufficiency to retire that debt from one or more of the guarantors.
And Your Honor, again, and the relevancy would be what? To retire the debt? And what does this have to do with the takings case?
They spent nothing except for you spent an hour and a half or 2 hours on it.
You know
So
what?
I can,
You know
if I
why?
can just
You know
answer
why?
the, if I can just answer the question,
May I be heard, Your Honor?
I'm not done.
Well,
If I can finish my sentence, if I could just finish my sentence.
I'm addressing myself to the court, which is the proper decorum of court proceedings. I'm asking the court if I can be heard.
You can what?
I'm asking the court if I can be heard on this matter.
Okay, go ahead.
The reason that I was questioning the witness about these documents was it's all about water rights. It's all about water rights and collateral for purposes of this loan and whether or not water rights are valuable and whether or not water rights have been set forth as collateral for a $150 million loan. That's highly relevant. Mr. Sino's net worth in 2007 is irrelevant, Judge, to these proceedings.
If I may respond, Your Honor.
Yes.
If that were true, they wouldn't have spent so much time asking Mr. Whittemore whether the bank relied upon this permit as collateral, as if it had no.
I agree. Overruled. Go ahead.
Did you want to go dark?
Judge, if we're going to be talking about Mr. Sino's net worth, I would like to go into a confidential session, yes.
All right, so we're
Well, ladies and gentlemen, you see exactly what is going on here. The protection that Hutchison is so worried about. Oh my goodness, what a great coverage right there. He's so bent out of shape, and look at him. You get to watch him. I mean, they didn't go dark, but they definitely closed off the audio. Good job, Sylvester. You got him riled. You got him riled. And even the judge doesn't mind. He's like, whatever, let's go over this.
Okay. Lindsay, if I can turn you to 497, please. Same exhibit. It's section at the bottom, Roman numeral, or X, I should say. And can you enlarge that, please? All right. And so, Mr. Whittemore, this is a subsection of 7.1, which is the representations and warranties. And it indicates that schedules 7.1X and 7.1Y heretofore set forth a true and complete listing of all water rights currently available as potential sources of water, parenthetically, or in the process of being assigned or acquired for availability for the development of the borrowing-based properties owned by Coyote Springs and Red Hawk. And so it says currently available as potential sources. Did you read that, sir?
Yes, sir.
Lindsay, if you would please turn to 558. And highlight the first section, please. So this is schedule 7.1X that we just looked at in the preceding paragraph. And it says water rights currently available or in the process of being assigned or acquired for availability for the development of the borrowing properties, base properties owned by Coyote Springs. And then there's a reference of the number of different water rights, not by permit number, but by acre feet. And it references the 8,600. And do you recall, sir, that was the gross amount of total water acquired from Aerojet in the transaction?
That's correct.
And then there was the additional purchase. That's the $5,000 or 5,000 acre feet from Nevada Power or Nevada Energy.
Nevada Power, correct.
We'll never get that right.
It's hard.
There's a reference to the sale of the 9,000 acre feet to SNWA committed to Fish and Wildlife. Is that right?
Correct.
And then conveyed to CC. That's the GID, correct?
That's correct.
And it goes on to say, and that's 3,140. Goes on to say remaining CSI owned water rights available for development within the Coyote Springs Valley Basin as of June 1st, 2007. And then there's a list. 9,000 acre feet, CSI is the process of acquiring these rights from SNWA. What it says anyways, correct?
Correct.
Okay. And this is 27,150. That's the point of diversion is the Coyote Springs Valley. And is that what you had anticipated might be approved from the 108,000 acre feet application?
That's what I believe that to be the case,
Okay.
but it wouldn't be because the next line is a double counting of 108. So I think it's saying that those would be base rights, and then you go to the next 108,000.
Okay. And you can see in the comment section, it says subject to 2-year pump test and submission of an updated report. And we find that obviously from 1169, agreed?
Correct.
Okay. It's actually a 5-year test, but 2 consecutive years. You recall that?
Yes, sir.
Okay. And then 108,000, again, this is subordinate to the 27,510 pending application held by SNWA, subject to, again, the same pump test. And that totals, if it was available to CSI 147,595 acre feet of water. Agreed?
Correct. Agreed.
And then there's the additional water rights potential within. I'm sorry, the next section is the list below reflects other offsite water rights, either owned, i.e. CSI Tuffy Ranch, under option, i.e. Cane Springs and California Wash, or under application, i.e. Lake Valley Basin by Tom and Harvey. Still references CSI and Tuffy Ranch, that may be used for the benefit of Coyote Springs by either being used within Coyote Springs, being used to maintain economic activity, or being used to satisfy mitigation. And if we turn the page to 559, there's now a listing of the other total water right potential within other basins as of June 1st, 2007. And we can see them at the top. It indicates 32,435 acre feet owned by Tuffy Ranch Properties within LLC, a CSI affiliate. Is that part of the Tuffy Ranch property or water we've been talking about?
Yes, sir.
Okay. And apparently, at least the bank understands that these water rights are potentially available for the use in Coyote Springs Valley to support the master plan community. Agreed?
Agreed.
Okay. Then we have the other groundwater rights of 2615 under contract to purchase from listers, and that schedules to close. Can you just tell us what that lister reference is?
Yes, that's from Bevan Lister. We were in the process of negotiating water rights from Mr. Bevan Lister.
There's the reference to the 1,000 acre feet we talked about from Lincoln County and Bidler, right?
Correct.
There's 17,000 under contract to purchase from Lincoln County Water.
Those are the negotiations which are ongoing with respect to what Vidler had advised Lincoln County and therefore us that would be
Right, you
potentially
talked about,
available.
I'm sorry to interrupt you. You talked about that yesterday a little bit.
Yes, sir.
Okay. 74,929 groundwater applications, Lake Valley. You had pending applications in Lake Valley separate and apart from Tuffy Ranch.
Correct.
And then there's a number of different references to some certificated surface water rights owned by Tuffy Ranch.
Correct.
Okay, so the total water rights potential within the other basins was 140,258. So when you were being examined yesterday about the need and necessity and the collateral reliant upon 4677, that was not the only water that you suggested to the bank would be available for the development of the master plan community.
That's correct.
Objection.
Oops, sorry.
Sorry, it directly misstates the testimony and it directly misstates the document.
I just asked him.
It's his testimony, but does, you can so say.
I think that the document states what we believed were the assets available within the basin and the assets outside the basin that were potentially available through the Southern Nevada Water Authority pipeline or through other means to get it down to Coyote Springs.
I read it the same way.
Okay.
And then the next page at 560, this is all of the water rights owned by the co-borrower guarantor, Red Hawk. Is that fair?
Yes, sir.
And those water rights also serve as collateral, do you recall?
Yes, that's what the idea was. Not the idea, that's what was reflected in the schedule.
Linda, if I can turn to 602, please.
Page 602 or
No, 534 602.
Okay.
Yes.
Yes.
Highlight paragraph 5, please. And you and council spent some time on this particular provision, and it's an additional representation and warranty. And the item number C, Lindsay, if you could just highlight that all the way to the end of the sentence. Adequate water is projected to be available to permit full development of the Coyote Springs to property on a timetable consistent with the projected development schedule, therefore, and consistent with the types and density of the projected uses for such property. Now, a couple of things. The entire development is the entire master plan community across both Clark County and Lincoln County. Agreed?
Agreed.
Okay. And what you are doing here is representing to the bank that the water that we've just looked at, all or a portion of it, is projected to be available for the development. Agreed?
Correct.
Okay. Doesn't limit it to 4677. It says the water that we've now discussed is projected to be available. Okay?
Objection mischaracterizes the document. Document speaks for itself.
Sorry, Council.
Not a warranty for representation by CSI or by you that water in any of the permits is guaranteed. Great.
Objection calls for legal conclusion, lacks foundation.
You can say his understanding of it.
It is, and I'd have to check if we could go to a defined term, Your Honor, borrower, because this is applicable to the borrower, and I'm not sure that the guarantors are included in. So your question, I thought.
Fair point. Let me withdraw the question, limit to the document.
Well, can I ask Your Honor, may we find out if borrowers include the guarantors?
100%. I'll get to the definitional section.
Thank you.
Just take me a
I'd
second.
like my answer to be accurate with respect to. Because I believe there's a distinction between borrowers and guarantors. It may or may not be in this case.
I'm almost there. Found the definition that sends me somewhere else.
Okay.
If Lindsay, go to 439, please.
Sorry.
No, it's a fair clarification. I'm glad you made it. And you can see the prefatory paragraph. And as an aside, the definition of borrower returns you back to, so we have a clean record on it. It says borrower has the meaning set forth in the introductory paragraph.
Yes, and I don't see my name or Tom's name as guarantors, and therefore the section that you referenced is a defined term because it's capitalized, would apply to those entities making the representations, and then the guarantor language would be what would apply to the guarantor.
So thank you for that clarification. You, as the manager of the entity, on behalf of the entity, did not guarantee that all or any portion of the permitted water would be available in the future to support the development.
Objection calls for legal conclusion, mischaracterizes the document.
Was that a question or a statement?
Mine
Yes.
was a question.
Okay.
Agreed?
Agreed.
I mean, you couldn't guarantee that water would be available in the future. Could you, sir?
Objection lacks foundation, calls for speculation.
Overruled.
I didn't guarantee it in the amended and restated revolving credit agreement, and I didn't guarantee it, I don't believe, in any other document that I signed.
But you can't. You can't guarantee that permitted water, subject to the conditions and the right to regulate it, would be available in the future for development. Would you agree with that?
Objection, the question was just asked and answered, Your Honor.
Overruled.
I agree with that.
Because a permit is not a guarantee of water available in the future, right?
Objection calls for legal conclusion.
You state his understanding.
Agreed, that's my understanding.
All right, 10-minute recess now. We convene at 10 to 11.
All right.
Well, there you go. We're going to a 10-minute early morning recess here with Day 17, Coyote Springs LLC versus the state of Nevada with W4Nevada Live. I'm Matt Winterhawk, and you are watching continued coverage of a trial that has been going on for years for $1.5 billion in a takings case currently against the state of Nevada for CSI, or Coyote Springs Investments, 159,000 home, I don't know, Clark County, Lincoln County split. If you want to know more information about it, please do look it up. And thank you again for tuning in, each and every one of you, from Carson, Churchill, Clark, Douglas, Elko, Esmeralda, Eureka, Humboldt, Lander, Lincoln, Lyon, Mineral, Nye, Pershing, Story, Washoe, and White Pine counties, all 17 here and accounted for, not just 2 in a sports book. We'll be right back after these messages. Actually, I don't have messages. Have a good day, guys. We'll be right back.
Vegas shine, that's the stage. But baby, we're more than the glow. From Carson City to the back roads, we got that old state soul. Churchill ride, clock keep moving. Douglas wind through the pines. Elko sky, Esmeralda dreaming. Every mile got a line. Hear that name roll slow, like a river through the sand. One state, one home, in every county, man. We're Nevada, baby. Nevada all the way. We're Nevada, baby. From the night to the day. Carson City. We're Nevada, baby. Nevada all the way. Eureka Gold and Humboldt rivers, land of hills in the sun. Lincoln dust, Lyon County calling. Mineral, we sing along. Nye County moon, Persian heartland. Story got that old school flame. Washoe shake, White Pine rising. Say it, baby, same sweet name. Hear that name roll slow, like a promise in the land. One state, one home, in every county, babe. We're Nevada, baby. Nevada all the way. We're Nevada, baby. From the night to the day. Oh, no. We're Nevada, baby. Nevada all the way. And when the horns start crying, we remember every road. Not just the bright windows, but the ones that hold the load. Carson City, Churchill. Carson City, all the way home. We're Nevada, baby. Nevada all the way. We're Nevada, baby. From the night to the day. Carson City.
There's a place that don't need permission to feel like home to me. Oh, follow roads where the dust remember names, names, names. Where the desert meets the hills. You'll feel it in your chest when you stand still. This land give 1,000 chills. Let it breathe. Home is an area. Yeah, it do. Home is the hill. Stand tall. Home means the sage and the pine of it. All of it out by the Truckee. Silver, silver, silvery rill. Shine on. Out where the sun still shining. Always shine. Always. This is the land I love the best. Fairer than all I can see. Deep in the heart of the Golden West. Home means Nevada to me. When the sun goes low at the close of day, golden hour, paint the whole west sky red, so red. My heart drifts back to the desert gray and the mountains over my head. Over me. Moonlight dance in the shadow plan. Soft, soft. Hear the night breeze slow. From the fawn and the dough to the morning glow. This the only place I know. I know. Home is Nevada. Yeah, it do. Home is the hills. Stand tall. Home is the sage and the pine of it. All our weather by the Truckee. Silver, silver, silvery rill. Shine on. Out where the sun still shining. Always shine. Always. This is the land I love the best. No debate. Fairer than all I can see. Right in the heart of the Golden West. Home means Nevada to me. To me. Yeah. This ain't just land, it's memory. This ain't just ground, it's ancestry. This ain't a place you copy paste. You gotta earn the way it shaped you. Home is Nevada. Say it loud. Home is the hills. No fear. Home is the sage and the pine ivy. Roots deep down by the Truckee. Silver, silver. Shine, shine. Out where the sun still rising. Always shine. Always, always. This is the land I love the best. Know the way. Fairer than all I can see. Right in the heart of the Golden West. Home is Nevada. To me, to me, to me, to me, to me. Right in the heart of the Golden West. Home is Nevada. To me, to me.
Yeah. Yeah. Nevada. Yeah. Yeah. Pull up on Nevada, feel it. Bet the ground shake when we move. Hot as it hit like sunlight. State flag wave when we cruise. Build it from the dust up. They doubt us, now they copy the groove. County by county, we solid. Same spine, different views. Made it out the hard way. Long roads, no silver spoon. Sign my name on real things. Step off planes to open skies and moons. Locked in, don't ask me about the clout talk. I might just stare at you. Locked in, don't ask me about the clout talk. I might embarrass you. Stand tall in one boots on cold stone. Holding ground steady, make 'em fall slow. Sunset, gold match the snow tone. No front in this, stay home. Lay a lamp for sagebrush and railroads. They say they know us, but they don't though. Run laps around the talk shows. Hear our name echo in town halls. Yo, Nevada, where you been at? Everywhere, still working hard. 2-lane nights, wide open days. Long miles in every yard. Quick to stand up for the land. Don't push us, don't get me started. Locked in with the neighbors and locals. We keep it guarded. Everything I wear got dust on it. That mean it's activated. I was quiet when they slept on us. Now they act like they made it. Independent, proud and grounded. That's the state reputation. On top of the map for a reason. They try to underestimate it. They know this place authentic. Yeah, we live the truth. Stop over talking, show up, see what presents do. Standing on business in plain boots. Before I let this place get reshaped, I'll defend rules. Stand tall in warm boots on cold stone. Holding ground down, steady, make 'em fold slow. Sunset, go match snow tones.
I think we'll flip it back over here. Thank you and welcome back to W4Nevada Live. My name is Matt Winterhawk. You are tuning into day 17, continued coverage of Coyote Springs LLC investments and many other subsidiaries versus the state of Nevada in a $1.5 billion takings case. I don't want to give up that money. The water was ours to begin with. That's how I figure it. But anyways, we'll watch as they deliberate today and continue the cross and examination of Harvey Whittemore and recross. Enjoy watching Jeffrey Sylvester frustrate Mr. Hutchison today. We're going to have to clip that where he was getting all huffy and puffy and wanted to go into a confidential session. Here we are back. Ladies and gentlemen, thank you so much for tuning in today. All 17, not just 2 in a sports book. Thank you. Have a great day.
Can you ask who Arthur Berg is?
Yes. Those of you on Zoom, can you hear me in the courtroom?
Yes, we can hear you.
Wonderful. Mr. Arthur Berg, can you please identify yourself?
Tell me, muted.
Mr. Arthur Berg, you're muted. Can you please unmute and identify yourself?
Hey, Mark, would you tell, probably 2 hours on that?
Mr. Arthur Berg,
Okay.
can you hear me in the courtroom?
It keeps trying to move.
May I see it on order?
Be seated, please. We're back on the record. The witness has retaken the stand. And you may proceed.
Take your arm.
We still didn't get an identification.
Oh,
Sorry. You don't want
trying
to
to,
answer.
we're trying to get an identification of somebody on Zoom, John.
Oh, okay.
Arthur Berg, BERG.
What's that?
I said, we can't.
Right. Who is it?
We don't know. Madam Clerk has asked, but he's muted, so.
Because there's a name, right?
Yeah, Arthur Berg, I'm sorry.
Oh, that's okay.
Bottom right.
Arthur Berg? Arthur Berg, please state your name. You're muted.
I suppose we could just mute him and tell
Yes.
him to enter a chat to the extent he can identify himself.
I agree. So ordered.
Think,
Do you want me to boot him off?
yeah, and maybe suggesting that he can, in a chat, he can identify himself. If he can read the chat. Neither one of us know who he is from. He's not a potential witness on our side.
Yeah, he's not on our side either.
May I proceed, Your Honor? Looks like he's been taken down. Ms. Whittemore, we were talking about whether you could or would, CSI, guarantee water availability. And your response was, I believe, you would not and could not. Agree? Yes. Okay. Council showed you in connection with the pledge of the water permits I think it was a 70429 and 70430. Do you recall that generally?
Yes.
And recall in our prior discussion, you had shown you those permits, and it reflected the conditions, including the existing rights prohibition. Do you recall that?
Yes.
And the right to further regulate, agreed?
Agreed.
And that it incorporated essentially the permit terms of 4677, agreed?
Agreed.
And that would include the pumping or the monitoring program.
Yes. Before and after, you have to.
Also require the annual reporting of the pumping to the state engineer to the extent that he needed it to essentially further regulate it going forward. Recall that generally?
Yes.
And at the time of the pledge, the pump test still hadn't occurred, agreed?
Agreed.
One of the questions that council asked you yesterday was your response to one of his questions was you couldn't give away more than you own. Do you recall that colloquy generally?
Yes,
I
General.
don't think you were given the chance to expand on that answer. What did you mean by that?
Your Honor, in the context of guaranteeing a loan that has a basket of security, you, if you said, I'm going to pledge collateral of an apartment building that you didn't own, and it was somehow listed that you owned 100% of the apartment building, you can't give to the bank something which, in my mind, is not owned 100% unless it's disclosed that you own 46% or 22% of a particular asset. So what I was trying to suggest is that with respect to water, you could only give that which was identified by the state engineer as being subject to appropriation, available, put to beneficial use. In other words, on that continuum of trying to develop the water resources, you have to take a snapshot of where you are in that process.
And in this case, you couldn't transfer or pledge as collateral a water permit free and clear of the conditions of that permit.
That's the point.
No different than you couldn't transfer real property free and clear of an encumbrance of record.
That is exactly what I'm suggesting, or an ownership interest, which is not accurately reflected.
That you don't own.
Correct.
Seaside doesn't own the water, it just simply owns the permit, correct?
It owns the right to appropriate.
Right. The public's water,
Correct.
subject to whatever the statutory scheme and the regulations are under the statutory scheme regulating water, agreed?
That's correct.
No different than if property is encumbered by an easement, you can't pledge it as collateral free and clear of the easement of record.
That's correct.
Council talked to you a bit about how sophisticated, my word, perhaps not his, that these syndicated lenders were. Do you recall that colloquy you had with council?
Yes.
It included part of the syndicated lenders, international lenders, including the Bank of Shanghai,
Bank of Scotland, Bank of Shanghai. Yes.
and certainly some domestic lenders as well that were also, in your view, sophisticated lenders.
Very.
And fair to say, sir, that you would have provided to them, and in connection with the pledge of the collateral, the permits that you were pledging, agree? CSI was pledging.
Yes, they would have had all of that information.
And I don't recall if you testified to this, were you involved in providing information in connection with the bank's due diligence?
I was, let me explain, Your Honor, the circumstances surrounding how the syndicated loan came to be. I didn't have relationships with those particular lenders. At the time, Tom Sino and his chief accounting officer, Larry Gunderson, developed and had the relationships with those lenders. And as they negotiated the process of attempting to get the original credit line and then the expanded syndicated credit line, they would have had multiple dealings with them. In the course of providing due diligence, I was asked to provide and had meetings with people and provided the general nature of the project. And then that would have resulted in requests for certain documents. I didn't personally provide those, Your Honor. That would have been provided by people on our management team.
Just, and maybe I missed your answer. Did you negotiate the terms of this loan?
No, I
This
did
credit
not.
facility? I'm sorry.
No, I did not. Sorry.
Did you negotiate, this is an amended and restated. Did you negotiate the 2005?
No, I did not.
Who negotiated, if you recall, both the 2005 and then the amended and restated?
Larry Gunderson and with the help of Brad Mommer and Tom Sino directly, I would have asked Larry and Tom what the status of the negotiations were. I would have met with the banks and provided information, but I didn't get into the nitty-gritty of what the terms were. Those were based upon relationships that were mostly Mr. Sino's. I did have a relationship with a banker at Bank of the West, and they were a participant in it, but it was not the driving force.
And just remind the court, if perhaps you already did, that Mr. Gunderson is essentially a representative of Tom Sino.
Correct.
And was he an attorney or an accountant?
Accountant.
But from a perspective of providing your financial information, that would have been something you would have given in that due diligence process.
Yes.
Excuse me, can you turn, Lindsay, to the same exhibit 534, but go to 604, please? This is Schedule K1, and it's existing agreements, entitlements, and related studies. I just want to work through a few of these with you. By the way, do you recall that the real property on both the Clark County and Lincoln County side served as collateral for these loans?
Yes, they did.
And so you're providing, and we'll work through a few of these, the memorandum of agreement by between U.S. Fish and Wildlife Services, BLM, and Coyote Springs. And that's perhaps the earlier memorandum you're referring to in 2021?
Correct. 2001.
2001.
Thank you.
Thank you.
Mhm.
Item number 8, it is the public facility needs assessment dated April of 2002. And we talked about that some last time you were here, what the PFNA said.
That's correct.
Do you recall generally that PFNA indicated that for the Clark County side, CSI was needing essentially 22.5 thousand acre feet of water?
Yes, in excess of 20,000 acre feet.
Okay. Then there's a reference to the specific plan approved by Clark County in 2006. And then we find our way down to item number 14, and it's the Coyote Springs Lincoln County GID. That's information that was provided in connection with this loan.
Correct.
And this information is being provided so that the bank can understand the nature and scope, if you will, of the master plan community.
Yes.
If we go to the next page, please, Lindsay, 605. We have the number 15, the Lincoln County Fire Protection and Emergency Services General Improvement District, another GID, correct?
Correct.
Number 16 is seems to relate to the GID for Clark County, agreed?
Agreed.
Okay. Also indicates that the service plan was provided for its consideration.
Yes, sir.
And then at number 17 is that multi-party agreement we looked at yesterday, dated 2006.
That's correct.
And then there's at number 18, providing to the lender in 2007, the Coyote Springs multi-species habitat conservation plan for both Clark County and Lincoln County.
That's correct.
Next page at 606, we can see the at number 19, 20, and 21, Lincoln County PUD. You see that 2004?
Yes, I do.
Okay. Lincoln County Development Agreement has 2004. And
Yes.
the development agreement between Lincoln County and Coyote Springs of 2005. And then there, excuse me, then the item number 22 is the master design guidelines. Is that something we looked at yesterday?
Yes, generally those were the guidelines that we talked about that were adopted to protect the integrity of the community.
Both sides.
Seamless.
Item number 29, we see the master CC&Rs for both recorded in both Clark and Lincoln County. We talked about those yesterday, agreed?
Yes, we did.
Also has the item number 31, appears to be the Nevada Florida Land Exchange Act in 1988.
Yes, there's a reference to 31, and I don't know what the public law reference is in 24. They might be the same thing. I'm not sure.
You know, sir, that in this case, we had seen title reports provided by CSI that reflect as an exception the Nevada Florida Land Exchange Act. Would that surprise you, sir?
No, because there were conditions within the act itself which imposed obligations on the recipient of the exchanged land.
The 42,000 acres.
Correct.
And recall that Nevada Florida Land Exchange Act applied to the entirety of the 42,000 acres.
Correct.
If we can turn to the next page, 607. Item number 44 reflects that the bank received the memorandum of agreement that we talked about that was in 2006.
That's correct.
And then 45 is the backup water rights agreement between SNWA, MVWD, and Coyote Springs in 2006.
Correct.
Go to the next page, please, Lindsay, at 608. References the agreement for the settlement of all claims in 2002. We talked about that in your first session. Do you recall that?
Generally,
Generally speaking, that was essentially a provision that was provided for the sale of, in part, the reserved water, the Aerojet reserved water of roughly 1,100 acre feet.
correct.
And then it had other agreements set forth therein.
Correct.
Item number 50 is the guarantee of payment and performance of the obligations of Coyote Springs, Lincoln County General Improvement District. And that relates to that capacity agreement we looked at yesterday.
Yes, it's the disclosure to the bank of the nature of the obligations of Coyote Springs to ensure that Lincoln County did not have any exposure with respect to the capacity within the proposed pipeline.
Right, and we saw in the schedule we looked at before that the potential source of water was the Tuffy Ranch water in part, correct?
In part,
And this capacity agreement reflected the manner in which hypothetically that water could be brought down to the master plan community.
correct.
And also at 609, at item 64, had the Part E agreements. They took a security interest, did they not, sir, in CSI's rights to receive proceeds from Part E.
Correct.
That Part E agreement we looked at yesterday also reflected the right of Part E to acquire property and develop it in the entirety of the master plan community.
That is correct.
Thank you, Liz. You can bring that one down, please. Oh, I'm sorry. 1 second, Lindsay. I want to go back to 534-668, please. And you talked about this with council, and this was the completion guarantee. You recall seeing that document yesterday?
Yes.
Okay. Just peruse it, sir, generally, and tell me whether or not you guaranteed as a guarantor the sufficiency and availability of water.
Well, under that agreement, there isn't a specific guarantee regarding the availability of water.
And you did not guarantee it.
I did not.
And they didn't ask you to.
No.
Fair to say you wouldn't have guaranteed them.
Objection, document speaks for itself. So do all the other prior documents he signed.
The question was fair to say he wouldn't guarantee it.
Same objection, mischaracterizes the evidence in the case.
Overruled.
Depending upon what the terms were, if they said that you personally have to guarantee a source of water, it would mean that I'd have to truck water in. I don't think I would have done that.
We can turn to 534-1181. This was the repayment guarantee we talked about. Same question, same answer with respect to guaranteeing water, sir?
As soon as it comes up on the
Oh,
screen, I'm sorry.
Sorry.
I just want to make sure I'm referencing the right thing, Ron. Yes. Now wait a second. This one talks. Okay, they're still making a distinction between guarantor and borrowers. The borrowers are listed and we're not one of the borrowers, we're just the guarantors.
Okay. Thank you, sir, for the clarification. Lindsay, can I go to 534-761, please? And this was the 2005 revolving line of credit. This was the $30 million loan. Just take a moment to refresh your recollection of the document with.
Yes.
And if you go to 769, please, Lindsay. This is a loan by between, at that time, the Wells Fargo Bank and CSI. Agreed?
That's correct.
In connection with this loan, CSI pledged both real and personal property, agree, sir?
Agreed.
And that permitted collateral would have been the same 70429 and 70430, agreed?
In part, correct.
If you go, Lindsay, please to 534-868. 534-868. And this appears to be the appraised value of both the Clark County and Lincoln County property.
That's correct.
And do you see the appraised value at the time of Clark County?
Yes, sir. It's $115 million.
And certainly that would have been, in your view, if you have an understanding, the as-is estimated value.
Objection, lacks foundation, calls for an expert testimony.
I just asked if you knew if it was as-is value.
It would, the same objection would call for an expert testimony, lack foundation, Your Honor.
You asking for his understanding?
Yes, sir.
I'll allow that.
Yes, that's my understanding that the appraised value of the Clark County property as is was $115,400 and created a borrowing base.
And how much was the Lincoln County as-is appraised value to your knowledge?
Same objection, Judge.
Similarly, you can understand his understanding of what's stated in the document.
$72,600,000, which gave a borrowing base of approximately $36 million.
And then, so the total of those two for the borrowing base value?
94 million about.
And again, this is, we can look at 534871. Let me just take a moment, Your Honor, to talk to counsel. Right, wait till what is the various entities. Holy cow. Can you make it a little larger?
Do you want to go mute?
We're not gonna talk about it. They can't see the
Okay.
the document.
We don't want it to be, we want this to be confidential. Thank you, Your Honor.
You can take that down. Lindsay, can I go to 534902, please? Same exhibit 902. And this is at item 5. It's the same language you spent some time with counsel on yesterday. You recognize it generally?
Yes, gentlemen.
And item number C has the same language with respect to the adequate water is projected to be available to permit full development of the Coyote Springs property.
Correct.
Same question, same answers as it relates to what you understood the intent of that provision to be.
Yes.
Okay. Now, I want you to sort of marry this language, if you will, with the requirements under the amendment to the party agreement, and maybe even the original party agreement, that you had to use your best efforts to obtain water going forward.
Correct.
Did you understand this essentially to demonstrate that you're going to attempt to, in the future, obtain water for the projected development?
That's correct.
Not a guarantee.
No, sir.
At number 903, please. The first sentence, you talked about this yesterday a little bit. Coyote Springs currently owns 4,600 acre feet per annum of water rights for Coyote Springs as permitted by the state engineer. Does that suggest to you that it's subject to the same conditions, limitations it's set forth in the permits themselves?
Yes, generally.
And we can look at 668, I believe, of the same document. Let me just confirm that real quick. At 534668, and that's the completion guarantee that you spoke about again yesterday.
That's correct.
No guarantee by you that permitted water would be available for use in the future.
Not in connection with that document at all, no.
Not guaranteeing that water would be available free of any state engineers over or its ability to regulate that water. Is that fair?
That's fair.
Thank you, Lindsay. You can take that down. I think, let me just double check. Lindsay, can you bring up 3302, please? And you looked at this yesterday as well. This is the option agreement with the effective date of May of 2004. And let's just orient you in time to this document. Pump test still hasn't been commenced, right?
That's correct.
The MOU hasn't been entered into, at least the 2006. Right?
That's correct.
At 0013. Now, we talked about this a little bit on yesterday, I believe, or maybe the day before, that you knew and understood that Party was a sophisticated home buyer or a home builder.
Party and its parent, Weyerhaeuser, yeah, very, very
Just
sophisticated.
describe for the court what Weyerhaeuser was.
Weyerhaeuser, Your Honor, is a major corporation that's engaged in timber and land holdings, providing multiple services throughout the particular business segment. And they had one of their subsidiaries, Party Homes, which was a major home builder in the West.
Are they a subsidiary?
Believe so.
So back to 0013, and I think you testified, I know you did, that in advance of entering into the agreement, there was a certain due diligence period, whatever that time period was you testified to, and that you were, my words, cards face up and provided to them whatever information they needed to evaluate and enter into the agreement.
We exchanged significant documentation necessary for Party to move forward.
And at this time, you are negotiating Tuffy Ranch. We know that records a little later in the year, the acquisition, right?
That's correct.
And you have a general, at least an implicit understanding that that water's coming down through the SNWA pipeline.
We wanted that to be the case.
And you disclose that information to Party to the best of your recollection?
Yes.
And so at item number, or I should say paragraph B, Romanet 3, says buyer's receipt of satisfactory evidence that seller has sufficient water rights with respect to water services for at least 1,500 homes. Fair to say, sir, that CSI did not guarantee that that water would be available to build 1,500 homes?
Again, our obligation was to provide evidence satisfactory to Part D that we had access to sufficient water rights to provide water service. And that, in my mind, was 750 so acre feet of water. And I thought that we had that. So it's not in the form of a guarantee. It's saying, here's the information, you look at it, you understand what's involved. And we had significant discussions about, Harvey, how do we know that you're going to continue to be able to get sufficient water? And that's why we came up with this method of taking it down in segments. And again, as I indicated to the court yesterday, staying ahead of the game, that sort of concept.
And you did.
We did.
You used your best efforts and you obtained additional sources of water outside of the basins, outside of the lower White River flow system, agreed?
Agreed?
And that's one of the reasons why you wanted to buy the Tuppy Ranch water, is because it was outside of the lower White River flow system, agreed?
Agreed.
But this is Part E's determination, if you will, that they believe there is sufficient water rights with respect to water service for the 1,500 homes, agreed?
I'm sorry, repeat that.
This relates to what Part E believes from their review and from their due diligence that might be available to service the 1,500 homes.
That's correct.
They didn't ask you to guarantee that water be available, and you did not.
No, they didn't ask, and we did not.
And you can take that down, please. Can I have CSI's Exhibit 529? And this is that payment schedule that you were shown yesterday, and you had some foundation for what they had paid through the time period that you were still in control of. Right, and council focused on the first column, the single family payments that totaled $84 million. We could see that at page 2.
Yes, sir.
Okay, and then going back to the 001, there were also payments made on multifamily. Can you describe for the court what that references?
Yes, Your Honor. In November 6, I negotiated with John Lash and Cliff a modification to our original agreement that gave Part E the right to purchase multifamily units, Your Honor, rather than just single family units. And so that reflects the initial payment of, I believe, $14 million and then subsequent payments on land purchases.
So exclusive of the water commodity charge and the BLM easement, at least during your tenure, there was $126 million paid by Part E for the production home property and then multifamily home property?
Yes, by the end of that period of time, I think if you total those things, it's still, I'm still there. And if you take those two numbers, you get to the 120 million plus.
I did the math myself, so I wanted to make sure that we're not.
Well, it's over 120 million. Just add the 8 and 4 and we get to 120 million.
That's where you lost me in the adding part. Remember that your investment expectation at the time that you acquired the property or shortly thereafter was to find a home builder, title the property, find a home builder, and sell that land on a net basis. Agreed?
Objection, mischaracterizes witnesses' prior testimony to numerous questions over numerous hours of testimony.
Maybe counsel could provide me a page and line number of the question. This is the first time I asked this question to this witness.
It's his testimony, he can address it.
Thank you. Do you remember the question?
Yes. My development plan, as I've explained to the court, was to purchase the land, entitle the land, engage in business practices associated with getting it entitled both in Clark and Lincoln County so that I could present to a potential purchaser a master plan that involved very significant. I wanted it to be the largest community in Southern Nevada, which we did. And so after that, we get it entitled, we approach Part E and we enter into the agreement in 05 and sell the land on that basis, amend the agreements on that basis, and sell multifamily land on that basis.
And to be sure, you also wanted to find a builder that was going to put in what we talked about yesterday, the backbone infrastructure, and you did that.
Yes,
Okay. So fair to say that as of the date that you entered into the agreement with Party and the various amendments, you had satisfied, at least in part, your investment expectations.
Again, question's been asked and answered repeatedly. Object to the mischaracterization of the testimony.
Overruled.
I don't think that you think in terms of those specific words, Your Honor. You think in terms of, did I do what I was supposed to do in terms of entitling and selling the land at a profit? And the answer is yes. And therefore, is that an investment? Yes. You can properly characterize it as, did those things meet my expectations? They exceeded my expectations in the sense that we got a price which we felt was extraordinarily fair. If you took a look at that schedule where we indexed the purchase of the land between years 0 and 5, Party had a very, very compelling purchase price for the entire property. But after that, it went up significantly. So I thought we did a good job of getting the property in a position to be sold to someone who had the capacity to use it for their investment purposes.
And you're part of your investment expectations, at least as of the date that you formed them, whatever that was to sell that land, but reserve for yourself, seaside, commercial, recreation, and perhaps some gaming, correct?
That's exactly correct.
And that's exactly what you achieved by virtue of your agreement with Party, right?
We agreed to sell them the residential pieces associated with single family production homes and sold them land associated that we identified, Your Honor, during this process as multifamily. And we kept what we called the central core, the resort property and commercial properties.
Consistent with what you wanted.
That was our plan.
Just so that there's no ambiguity, CSI was not participating in the profits that Pardee achieved by building, marketing, and selling the single family production homes, et cetera.
True, other than I don't recall, as I sit here now, whether, as we explained during prior testimony, Your Honor, whether we retained premiums for golf course lots and or premiums for views, those sorts of things.
But that would be in the sale of the land,
That's correct.
not in the profit achieved in the sale of the homes by Pardee. Agreed?
That's also correct.
You can take that down, Lindsay. And if you would bring up 3417. We talked about this a little bit with council yesterday, which was the summer 2008, but maybe October, fall 2008 executive summary. Just orient you into the document itself.
Let's see. Mhm.
Okay. Just a couple questions on this. Okay, first, I want you, Lindsay, to do is go to 002, please. As an aside, Mr. Whittemore, do you prepare this document?
I don't. It's something which I explained to council. If we used it, it would have been sort of a takeaway that we would have left with people that we discussed this with. I didn't personally prepare this. It would have been prepared by one of our employees, and in all likelihood, prepared by Brad or Rob, other individuals on the staff.
Would you be involved in, well, I'll withdraw the question. On that first page, it has confidential information. And Lindsay, if you could just highlight and enhance the first paragraph. A little bit bigger for me. I'm sure Mr. Whittemore can read it. It's an executive summary of those water and ranch holdings currently held by Coyote Springs Investment and its affiliate Tuffy Ranch Property. Goes on to say this presentation may not be shown or given to any person other than those intended and may not be printed or reproduced in any manner. Any further distribution or reproduction in whole or in part, the divulgence of its contents is unauthorized. Why, sir, if you know, and I know you didn't prepare, why is it Tuffy Ranch Property included in that?
It was essential to give a more complete reference point to the recipient of what the status was at the time that this was prepared.
Was it intended to essentially convey to a potential reader that Tuffy Ranch has committed to allow its water to be used for the master plan community?
Well, we had an agreement that provided the obligation.
And Lindsay, you can just highlight the next paragraph, please. And it says that, excuse me if I can just approach a little bit, no representation warranty as to the accuracy, completeness, or fairness of such information is being made by the company or other person shall have liability or any information contained therein, or for an omission from the summary or any other written or oral communications transfer, sort of a disclaimer.
Very much so.
You were providing this to lenders, correct?
Not to my knowledge.
You weren't.
No,
Okay.
definitely.
This is 2008, and I want to sort of orient you in time if you have a foundation for this next series of questions. Do you know what the state, and again, from a builder's perspective, a developer's perspective, what was the state of the economy, let's say in the 2007 time period?
Your Honor, as you'll recall, there was a significant downturn in the economy associated with the events, mortgage fraud, number of things happening with respect to lenders not receiving payments on time, massive dislocation in the market with respect to the real estate environment. So we're going along with party, things are going great, and all of a sudden the Las Vegas market in large part just the bottom fell out.
But before that, right?
It was good.
Right. I've heard it been referred to as the zenith of our economy. The 2006, 2007 time period. Thanks for giving away money on student income loans.
Objection, Lex Foundation is to the zenith of the economy.
Sustained.
The
Sustained.
It's all right. Well,
Sorry.
did you understand the nature of our local commodity and or I should say local community and national community with respect to home buying, home sales and lending, if you have a foundation?
I was familiar with what the market was like in Las Vegas, which I explained in prior testimony, which was a reason why I wanted to purchase the land, was because I thought that land was a very valuable commodity in the Southern Nevada region and would make available lots and land to home builders who could generate a profit as a result of what I felt was lack of supply. I previously testified that Clark County specifically there's so much federal land on the surrounding edges of the existing community that I thought that Coyote Springs, being a large privately held piece of property, would add supply within the market. So I thought it was a good deal.
From the developer standpoint, I want to just kind of focus from 2005 to 2007, early 2007. From a developer standpoint, was the housing market increasing or decreasing?
Increasing. It would be considered to be a hot market here in Clark County.
And then you said a moment ago that the Great Recession hit sometime in the late 2007, early 2008 time period. Generally, you recall that?
generally what happened was you started to see softness all of a sudden be expressed, and then it was just sort of a rolling thunder turned into a disaster.
And I think that I've heard your testimony correctly, that it had an impact on Pardee. Did you say those words of like effect?
To a degree, yes.
What did you perceive the impact as that recession continued from the 2008 to the?
Objection, lack of foundation as to the impact of a recession on Pardee.
Sustained.
Do you know, sir, whether or not, and just from your knowledge, Pardee was affected by, as it relates to the continuing development of Coyote Springs by the Great Recession?
I believe that the recession impacted all home builders, including Pardee in Southern Nevada. And I believe that the recession impacted the pace and or willingness to spend money at levels that had previously existed. So was there an impact? Yes. I can't go to, a specific degree, Your Honor.
Did Pardee at least communicate to you that they were concerned with the recession during that time period?
Yes, in general discussions, we were collectively, the developer community was extremely concerned about what was happening in Las Vegas and the impact of defaults on homes, because what you saw is a neighbor default impacting the value of another neighbor, which impacted that neighbor and created a huge problem within neighborhoods within Las Vegas generally.
Did you, as a member or manager of CSI, come to understand that lenders began to restrict lending for single-family residences?
Yes, generally.
And did you have to think about that and consider that in connection with the ongoing development efforts?
We were concerned that there was going to be continuing impacts until a recovery started.
When did you have an understanding as to when that recovery started, just from your perception?
Objection, lacks foundation.
Sustained.
Or do you have some understanding or perception as to, from your view as a developer, the recession began to relent or to ease, if you will?
I have an objection, Your Honor. There's been no foundation laid for his understanding.
He's a developer that owns CSI that's building houses affected by the Great Recession. I'm asking if he has some, if he doesn't, he can tell me.
I'll allow it.
I have a general understanding, yes,
What is your understanding, sir?
that the recession started to recover, in my mind, late 09, 10, that there was clearly it's a rolling sort of process that hits a peak, and then as efforts are made to stabilize those institutions which are impacted by the recession, that you started to see people return to normal types of investment activities, one of which would be buying new homes, buying homes which are foreclosed upon, stabilizing the market.
Did there come a time, so just shifting gears for a little bit, maybe they're related. Counsel read from a deposition that you gave in an unrelated case, and it involved Pardee and CSI. You recall that?
Yes, sir.
Objection, mischaracterized what I did while questioning the witness.
Want to rephrase?
Sure. He was holding up a deposition and asking you about things you may or may not have said during a deposition in the Pardee litigation. Do you recall that colloquy?
It's absolutely untrue.
Okay.
Mischaracterizes the record before the court.
Okay, that was all the question. Did you testify in a deposition in the Pardee litigation?
Yes.
Do you have some understanding as to the litigation itself, what was at issue and what the parties had asserted one against the other?
I recall generally that there was a dispute between Coyote Springs and Pardee that ultimately resulted in a settlement between Coyote Springs and Pardee, yes.
Do you recall that the nature of this dispute in part was related to CSI's refusal to dedicate additional water to the GID?
I recall that there were a number of claims by both parties with respect to the status of the development, and there was a dispute between the parties.
And part of that dispute, I mean, see, let me withdraw the question. Who, at this point, when I say who within CSI is essentially responsible for, when I say responsible for the litigation in the sense of who authorizes commencement, if you will, and who monitors progress?
Mr. Albert Sino, Mr. Tom Sino, the owners of the CSI at the time.
You're still a member and manager at the time, right? Because I'll represent to you that the lawsuit, I believe, was filed in the 2010 time period.
I was a manager, but on my way out.
Did you ever actually read the complaint and the counterclaims, the claims that sort of one against the other?
I think I was required to look at it with respect to the deposition, yes.
Did you at some point take a less active role in the management of the company?
I did. I just explained that I was on my way out.
Yeah, but I'm just trying to.
Yeah.
Sorry, I heard your answer. I'm trying to understand.
Sure.
When that change in control, my words, occurred, just temporally.
I can't give you a specific date. Mr. Albertino basically said that my role was going to change within the company, and I can't give you a specific date.
That's fine. Not even a year. And the reason I asked you that the complaint was filed, my recollection, 2010. We have the record in this case, and I think you indicated it was Mr. Albert and or Tom Sino that was essentially authorizing that action. So was that does that orient you in time as to when that is Albert Sino, began to take a more active role?
Whatever the date of the complaint was, would clearly indicate to you that Albert was more in control.
I want to talk to you just a little bit about, before our lunch break, Jeremy Aguero. You had spoken to counsel on direct examination, and you respectfully indicated your opinion of Mr. Aguero. I'm not going to challenge you on any of that, obviously, to be clear. But I want to know, because it was unclear from your testimony, when Mr. Aguero began to provide support, analyses, or studies of CSI to the best of your recollection.
Well, it was post most of the entitlement work was done prior to Jeremy's involvement. I requested Jeremy to support decisions which we had made. Jeremy's role is to provide expertise, Your Honor, with respect to supporting decisions which the companies make and are asking for foundational financial information that's relevant to the decisions we made.
I deposed Mr. Aguero in this case, and he provided documents that related to reports or analyses that he did for CSI. Just foundation, I'm telling you that. The reports, the first report temporally that he provided appears to have been in 2007. Does that comport with your recollection generally?
Yes, sir.
Okay. And that first report, if you have a recollection, was to support, I think the entitlements, well, not entitlements, but the development of master plan community in Lincoln County. Do you recall that generally?
Generally correct.
But the decisions with respect to developing the master plan community and the scope and nature of the master plan community were made well in advance of employing Mr. Aguero in connection with the matters that he was opining to from 2007. Agreed?
Agreed.
The decisions, I think you said a moment ago that Mr. Aguero would provide information to you that were supportive of the decisions that you had already made. Is that fair?
I think that's fair.
And we see him providing expert reports and testimony in Lincoln County in support of the transfer of the place of use of the Tuffy Ranch property down to Lincoln County.
Yes.
And that would be one of the reports he provided as well, correct?
Yes, it would show that the financial burdens associated with doing what we wanted to do could be supported.
Did you ever make a decision based upon advice or opinions of Mr. Aguero, or whether you simply supportive of the decision you made?
Objection ambiguous.
Sustained.
So we talked a moment ago about how he would provide information and reports and analysis for you to support the decision that you had made. You recall that testimony a moment ago?
Yes, I do.
Do you have any recollection of him providing that same study or analysis before you had made a business decision?
I don't recall any.
He provided a report for you relating to your attempts, Mr. Borgel's attempts to obtain, I think, gaming entitlements. Is that generally accurate?
Yes, we had tasked Greg Borgel to provide advice with respect to the gaming enterprise district, and we wanted Jeremy to support a decision which I had made, Your Honor, to seek those types of entitlements.
And that, my records reflect that was in the 2008 time period.
That's correct.
And he did some work for the pepper mill, is that accurate?
Based upon my recommendation to the owners of the pepper mill, which included the Cinos, Mr. Paganetti and Mr. Caroselli, that ultimately I thought Jeremy did some work for the pepper mill.
Yeah, I only have probably another 10 minutes of Mr. Whittemore. I just want to check my exhibits if I can to make sure I don't need to introduce anything. Would it be okay if we took an earlier lunch of 5 minutes?
Yeah, we can recess now, reconvene at 1:15.
Thank you. Thank you.
Okay.
Well, there you have it, ladies and gentlemen. We're going to lunch recess. We'll be at 1:15 p.m. Pacific Standard Time. I do thank you all for tuning in today. W4Nevada Live, I'm Matthew Winterhawk. This is day 17, continuing coverage of Coyote Springs versus the state of Nevada and a $1.5 billion takings claim. I do want to say that thank you so much to each and every one of you that has tuned in. Make sure to share it out, talk to your neighbor, talk about this process, maybe tune into the court hearing, start to look at your local commission, your boards, school board, meeting, pharmacy board, whatever it is that gets you activated and motivated and ready to engage and serve civically. This is what it is, and this is what it's going to take to continue this work. 17 counties may start the work, but 50 states are going to have to carry it if we ever have any hope of getting back to what the Constitution afforded to each and every one of us. Thank you so much. Carson, Churchill, Clark County, Douglas, Elko, Esmeralda, Eureka. Oh my goodness. My brain is fried right now. Humboldt, Lander, Lincoln, Lyon, Mineral, Nye, Pershing, Story, Washoe, and White Pine counties, not just two in a sports book. Thank you so much for tuning in, and we will be right back after lunch. Have a great day. Oh yeah, and remember, we are not just Vegas. Read the whole map, okay? Have a good day.
We're not just Vegas, you're not. Read the whole map, read it. Lights don't run the state, no they don't. That's a small cap, small cap. We're not just Vegas. Look around, past the neon haze, past it. 17 counties, all of them. Different lives, same place, same soil, same soil. They think Nevada starting in on the strip. That's like judging a book off the cover it get. Vegas loud, yeah, but that's just a slice. Plenty state left once you drive past the lights. This town's where a handshake still means something. Where folks know the land and the seasons are blunting. Where work don't trend and patience is learned. Where votes still matter cause people return. We don't all gamble, we don't all party. Some folks wake early, boots, dusty coffee. Some places quiet, some places spread. Some rows long conversations with your head. The state breathe wide, not stacked in a frame. Don't shrink us down to a postcard name. We're not just Vegas, no way, no way. That service talk, surface, surface. Real Nevada, out here, outside the wall, outside, outside. This land where the sky feel heavy or blue, where the silence louder than the news. Places built slow, no rush to impress. Where people still show up, not just express. Some counties keep food on shelves you don't see. Some keep water managed responsibly. Some keep the lights on, roads still paved. Some keep the history from getting erased. Not every voice come with billboards and sound. Some carry weight just by sticking around. We don't move fast, cause we plan ahead. We don't burn bridges, just to feel said. Nevada ain't one tempo, one look, one lane. It's contrast stitched into the same terrain. We're not just Vegas, past the glare, past it, past it. The state move quiet, steady, everywhere, everywhere, all around, all around. If you move here, welcome, just learn the pace. Respect the ground, don't rush the place. We don't copy cities that couldn't hold. We're not just Vegas, yeah, nah, yeah, no. Read the whole map, read it, read it. Lights don't run the state, no they don't, no they don't. That's a small cap, small cap. No, we're not just Vegas. Look around, past the neon haze, past it, past 17 counties, all of them. Different lives, same place, same soil, same soil, same soil. They think Nevada starting in on the strip. That's like judging a book off the cover it get. Vegas loud, yeah, but that's just a slight.